All right. Hi, good afternoon. Today is Thursday, March 16th, 2023. Happy almost St. Patrick's Day, by the way. My name is Ashley Glover, and I'm here with attorney Deanna Eble, and we are happy to welcome you to our webinar, Planning for a Loved One with Special Needs. But first, let's get warmed up with a few housekeeping items. This presentation is scheduled for 30 minutes. We have our webcams on, and we're also sharing the PowerPoints. To help minimize background noises, your mics are muted, so you'll want to use the Q&A box to submit questions. We also received several during registration, and we've saved time at the end to answer as many of those as we can. Feel free to chat with us or among yourself using the chat box. Also, we are recording this and we'll email you a link to the recording. And finally, we value your feedback. So please let us know how we did in the webinar survey, which will appear on your screen once the webinar ends. All right, now I'd like to introduce today's presenter, Ms. Deanna Eble. Deanna is a partner at Rousseau Law Group. She focuses on elder law, estate planning, special needs planning, and Medicaid planning, and has practiced in these areas for 20 years. She's the lead planner in our Islandia office. She also meets with clients in Garden City, virtually, and home visits. Finally, Deanna is currently appointed to the executive committee of the New York State Bar Association. So thank you so much for being here, Deanna. Literally could not do this without you, so thanks. And I'll hand it over to you.
All right, thanks, Ashley. We should have coordinated and wore green today.
I thought about that as I said the dates, and I was like, oh,
Yeah.
it's St. Patrick's Day, almost. Okay.
All right, so let's dive in because special needs planning is certainly something that not enough conversation is had, and the more information you have, the more equipped you are to handle everything that's going on with your loved one. So we're going to talk today about special needs trusts, about government benefits that might be available to your loved one with special needs, and how decisions can be made for that individual throughout their life. So without any further ado, let's dive right into the special needs trust. I'm going to start first with the first party special needs trust. What is a first party special needs trust? And in understanding that first party special needs trust, we also want to understand how it differs between a third party. So the first party special needs trust is a very specific trust. It's set up either by the individual themselves, a parent, a grandparent, a legal guardian, or the courts. Okay, so the individual themselves can set this up. It's important to know that because that change happened only maybe 5 or 6 years ago in the law. It wasn't always that way, but the individual themselves can set this up. As long as the person that we're setting this trust up for is under the age of 65, then we can use this trust. And it has to be for the sole benefit of the individual under the age of 65. Meaning it can't be for, if I'm the disabled individual under 65, it can't be for me and my sister, it has to just be for me. One of the two biggest things with the first party special needs trust that are distinction from any other discussion we're going to have is the funds, the money that you put into this particular trust is the individual's money themselves. So in my example where I'm the disabled individual under 65, if I'm establishing this trust, I'm establishing this trust with my money. So it's money that's in my name or money that I inherited or that I got from a settlement or some kind of windfall. You know, a lot of personal injury settlements come our way for these types of trusts or inheritance, but it's specifically money that is my money. And the reason why we make the distinction about what money goes in there and who can set it up is because this particular type of trust, if there's any money left, for example, upon my passing, if I set this up and was disabled, the first thing that happens before anybody else can inherit from this trust is that Medicaid would, if I was on Medicaid, Medicaid gets paid back for any benefits that they paid out for me. So if there's $50,000 left in this trust and I was getting Medicaid services, the first thing that has to happen is Medicaid has to be notified so that they could submit a claim so that they can collect back funds that they paid out. It doesn't mean they're going to take it all. It depends on what services you got. And once Medicaid is made whole again, then any money that's left behind can go to loved ones of mine. Okay, so there's two big distinctions on this type of trust, and that is that it's funded with my own money, and Medicaid has to have there has to be a provision in there that says Medicaid gets paid back if there are funds left on my passing. That differs from the third-party trust. So the third-party trust, and just as a nuance, because we're mentioning it here, a first-party trust is an irrevocable trust. So the third-party trust is what we do in the office in an effort to do advanced planning for a family member that we know is disabled. So the third-party trust can be revocable or irrevocable. And how do you make that determination? Well, let's use a parent as an example. I decide to set up a trust for my son. And when I decide to set that trust up for him, I stop and say, okay, well, what assets am I putting in here? If I'm not going to put any money in there right now, but I'm going to say that my life insurance policy goes into that trust when I pass, then I'm likely going to make that trust revocable, meaning I could change it at any time because there's really not going to be anything in there right now. So I want some flexibility with it. If I'm going to put cash in there right now, some clients come to us who have estate tax concerns, and they want to do this kind of planning for a loved one who has disabilities, and they want it to be a way of getting rid of assets or securing assets so that they lower their tax burden when they pass. That trust would be, for example, irrevocable because they're trying to distance themselves from the money so that it's not counted in their estate for tax purposes when they pass. So depending on your situation and a conversation with your attorney, you will determine whether or not it's going to be revocable or irrevocable. You'll also make a determination of whether or not it's living or testamentary. Again, what does that mean? Living is something where it's a trust that's a standalone, it's established today, it's established within a trust. It may even be, instead of a standalone trust, I may do a trust for myself, and then in that trust, say, upon my passing, anything my son inherits from me, it's going to remain in trust for him. But all of that's done within a trust. And so it's considered part of the living the living distributions, or the living setting it up in your lifetime, where testamentary is specific to a will. So testamentary provisions are saying that I passed, I'm going to now put provisions in my last will and testament, which is what makes it testamentary. It's after death and it's part of your last will and testament. And in that document, instead of saying my son is going to inherit everything from me outright, it's very specifically going to have language that creates a trust under the will. And that trust under the will is going to have provisions to hold the money for my son so that he maintains his benefits and doesn't lose them. The trust is established under the will. And so the biggest difference between living and testamentary is, how are we setting it up for them? Are we setting it up with a lifetime document, or are we setting it up with something that only comes into play on our passing? And in all of these circumstances, the question that we have to ask ourselves is, well, what are we putting in these trusts? Are we putting the house in there? Are we putting cash in there? Are we making the life insurance the beneficiary of the trust? The beneficiary of the life insurance? Are we using retirement income for as the means of funding this trust? I know that one of the questions that came in referenced this concept of the retirement income. So just understand, when we're talking about retirement income, In the end of 2019, the Secure Act came out, which said that somebody who we'll use IRAs, for example, because most people think in terms of IRAs. IRAs often have what we hear out in the world as required minimum distribution, which is a minimum amount of money that is required to be withdrawn from the account once you reach a certain age, so that there's taxes being paid on that money, because most retirement funds are pre-tax dollars. And so the government said, okay, well, we want everybody to start taking it out at a certain age, so we make sure we get tax dollars for it. When the Secure Act came out, there were studies that were done that felt that most individuals who inherit retirement funds from a loved one spend that money within 18 months of getting the inheritance. Some people keep it on for a legacy, and majority of the people were spending it within 18 months. So the federal government decided that when an individual inherits an IRA or retirement funds, they had 10 years from the day of the loved one's passing to collect all of those funds, liquidate them, pay the tax, and move on. It didn't matter to the government how you did it, whether you collected it all day one or the very last day that you could collect, or spread it out over time, but you had 10 years to liquidate the funds and pay the tax that was owed. There are some exceptions to that. And one of the questions that I got was, well, what happens if my child is disabled and they're getting the retirement funds? So those retirement funds, if the child is the beneficiary of those retirement funds and it's proven that they meet the qualifications of disability under the Secure Act, those funds can be paid out in increments over their lifetime. They're not subject to that 10-year rule. There is also a way to have those monies put into a trust, similar to a supplemental needs trust, for the sole benefit of that disabled child or individual, so that they can continue in a trust to take it over their lifetime. So why would somebody do a trust, whether it's first party or third party, as opposed to just take the money outright? Well, we talk about first party trusts as a means of protecting assets, because the government benefits that are out there, many of them are sensitive to the assets that you hold. Ashley, can you just skip to the next slide? All right, let me discuss the pooled trust and then I'll finish that thought. The pooled trust is similar to the first party and the third party trust. Again, it is the same concept in how it is set up. The biggest difference with a pooled trust versus using your own first or third party trust is that on the disabled individual's passing, the charity will get some of those funds. So depending on the type that you set up with a pooled trust, there's portions that will go to the charity or the whole thing will go to the charity. But the pooled trust, the goal is for the charity to get some of the money, which is a great tool, especially in a circumstance where somebody doesn't have family to leave to. Letting the charity benefit after the individual had full use and enjoyment of the money is a huge thing. So getting back to it, you can go to the next one because I think that one's government benefits. So when we're talking about these trusts, so these three types of trusts and why people do it, they're doing it for asset management and to maximize government benefits like Medicaid and supplemental security income, which is often called SSI. Those two in particular are very sensitive to the assets that someone holds. So for example, the most restrictive is SSI, and somebody who's on SSI cannot have assets that exceed $2,000 in their name. So if you had a child, for example, like we keep using my son as an example, if you had a child who was about to inherit assets, or you wanted them to inherit from you, you don't want them to inherit and have more than $2,000 in their name because it could jeopardize the benefits they're on. So I had a client 10 years ago now who she was one of 10 or 15 nieces and nephews that inherited from an uncle, which was great. And when all was said and done, she inherited about $200,000, which sounds like a lot of money, but in her case, she was on Medicaid and SSI, and the uncle wasn't aware of that type of this type of planning for her, and just across the board gave money to all the nieces and nephews in his will without any protection in place. And while everybody else got their $200,000 and was able to spend it on luxury items, because she was on SSI, she lost her benefit. She ended up losing her benefit instead of for just 3 years. She lost it for 5 years because the $200,000 didn't come to her in one lump sum. It came in 2 payments. So SSI looks back 3 years, and the way that her payments came out, she was off of that benefit for 5 years. And for those who don't know, SSI is an income source. So it's supplementing any income, because the people who are getting SSI don't generally have an income source, or their income source is below the lowest threshold. So SSI can supplement it. And so because she now had no income source, she was using the $200,000 just to keep a roof over her head, where had the uncle thought it through or had a conversation with a professional who knows this planning option, he could have put that money in a trust for her, and she could have used it for things that weren't paid for, like dental work and stuff like that, as opposed to just using it to keep a roof over her head. So if you know somebody that you want to inherit from you and you're concerned that they're getting Medicaid and SSI, these trusts are the way to do it. First party is if it's money of their own. Third party is if it's your money. And revocable and irrevocable have to do with what's going in there and when. And I know just in that conversation, a question came up that says, can the established supplemental special needs trust be the beneficiary of a retirement account under the Secure Act to allow for the funds to spread over the lifetime of a beneficiary or a second supplemental needs trust? So the answer is you can use a supplemental needs trust to be the beneficiary. You have to be very careful, and that's something that I would say you don't want to just take the trust that you have and name your IRA as the you don't want your IRA to have this supplemental needs trust that you have named as the beneficiary, because you want somebody who knows this stuff, like come to us and have us review it, because you want to make sure that there's language in the trust that allows for that stretch over the lifetime. You want specific language in there to make it clear that we're stretching over a lifetime. So the answer is yes, the trust can be a beneficiary of the IRA funds, but before you just go and do that, have an attorney like us review that so that you make sure that the proper language is in there. Okay, I think that we can go to the next slide. And so what government benefits are out there for your loved ones? We touched on it a little bit. The money aspect is SSI and Social Security disability. So what's the difference between the two? Because we oftentimes get that question. Sometimes people aren't sure about those things. Supplemental security income, which is SSI, and the most restrictive of all of these different benefits, it's a monthly stipend of income that goes to an individual who did not work in the Social Security system enough to qualify for Social Security benefits. So it could be that they're a child who turned 18 and then they had disabilities that didn't allow them to be in the workforce at all. Or it could be somebody who is older but didn't work enough in the workforce. An example I can give you, or let me actually rephrase that. One of the things that you need to understand is that when we're talking about Social Security benefits, the younger people don't require the same amount of time in the system in order to qualify for the benefit. So there's a table out there. You could search on ssa.gov and they'll show you how much you had to have made in what time frames in order to qualify. And knowing that somebody who's younger likely was the average person might have been in school, in college, and they weren't working at the same rate. They don't need the same requirement for work history that somebody maybe in their 30s or 40s would need in order to qualify for that benefit. So it is a little bit of a sliding scale. Social Security disability insurance, SSD, is just collecting your Social Security benefit before you're actually full retirement age. It's saying, hey, because of my disability, I'm not able to work anymore, but I paid into this system. And so rather than take a penalty, because if you collect Social Security before your full retirement age, there's a 25% reduction in your benefit. So to not have that reduction, if you're looking for Social Security benefits because of a disability, if you qualify under the disability provisions, they don't charge you that 25% reduction. They allow you to get the Social Security benefit, which if you then get the Social Security under the SSDI, you, after 2 years of being eligible for it, are eligible for Medicare. SSI, the Supplemental Security Income, brings with it Medicaid, because Medicaid follows the same rules as SSI for qualification, but SSI is more restrictive on how much they allow the individual to have asset-wise. Is a person on SSI classified as disabled? Yes. Okay, if you're getting SSI, then you went through a disability process and you're classified as disabled. So that's the money side of it. That's income coming in from the government. The medical side of it is either private insurance, Medicaid, and if you qualified for Social Security disability, at some point you also qualified for Medicare. I apologize that I didn't put this on the list, but Medicare isn't sensitive to the assets you're holding because it comes with Social Security disability. Next slide. SSI and Medicaid are waivered programs. They're financially means tested. So what do I mean by that? I mean that they limit the amount of assets and income you're allowed to have in order to qualify for those benefits. So financially means tested in an SSI world, you cannot have more than $2,000 in your name to qualify for that benefit. If you're married, they do look at the spouse. It could disqualify you if they're looking at the spouse, unless the spouse is also disabled, and then there's some exception made. But a husband and wife is usually $3,000 of income. Of assets. Income-wise, what happens with SSI is it's not a dollar for dollar calculation, but they have the first 60-something dollars is exempt. And then after the first 60 some odd dollars of income that you've made on your own working in the workforce, after you've gotten to that certain point, and everything after that it's like 2 for 1. So for every $2 you make, there's $1 that is reduced on your SSI benefit. The question that I also get a lot is, can somebody have SSI and SSD? And the answer there is yes, because SSI has a maximum amount that they allow for income. And if someone collects Social Security disability, SSDI, and that number is less than the maximum allowed for SSI, they can get both. So in theory, somebody could have SSI, SSD, Medicaid, and Medicare. It doesn't happen a lot, but it does happen. So you understand from the financial means testing that there's limited assets and income allowed, and these are waiver programs for Medicaid, which waivered programs are ways of getting in the Medicaid system without necessarily needing home care or nursing home care and stuff like that. Next slide. Hold on, I just want to. I'm trying to answer your questions. What are the criteria for being classified as disabled? The criteria for classification, it's a process. Social Security goes through they look to see if you're gainfully employed. So there's an amount, it's a little over $1,400 a month. If you're not able to work and make $1,400, a little over $1,400 a month, they don't consider you gainfully employed. That number is slightly different for somebody who's blind. They get a more of an allowance. And it's an application. They go through, they look for stuff from your doctors. They want to know what your disability is. They want to understand why you can't work. In some instances, they may deny on the first go around and look for a hearing for a judge to determine whether or not you can do something, bag groceries at the grocery store or something like that. But it is a process. And if you have more questions about that, you can certainly reach out to us, and we will have a further discussion with you, because it's not an easy answer, because there's so many different variations. Are touching on disabled adult child benefits, the DAC. Most people don't know or understand about am I touching on them? So the DAC program, which is disabled adult child, has to do with somebody who is collecting, for example, SSI as an individual. They aren't married. Their parents, they've been, with their parents, and a parent either retires or passes. Then there's an opportunity for them to collect Social Security benefits off of their parents' record, which would give them a higher number in almost all cases. And those benefits are available to individuals who are not married and are disabled before the age of 22. So there's some criteria in there also. Is a dual Medicare and Medicaid automatic when one also receives SSI and then receives dependent Social Security? Well, there's the 2-year time frame, and I don't think that anything is just checkbox automatic in the government benefit world. So I would need to have more information to give you a more specific answer to that. Is blind and legally blind the same as far as classification? Not necessarily, because there's distinctions between legally blind and blind, but likely the criteria will still get you a disability rating. We'd have to see the documentation to be able to give you a more specific answer to that. Okay, next slide. So many people who have children who were disabled either at a young age or at birth are very familiar with the fact that once your child turns 18, they're considered the age of majority and they can make their own decisions. And so the question you have to ask yourself is, based on the individual themselves, are they able to make decisions, even though they have a disability of some type? Are they able to rationalize and make decisions and have discussions? Because the understanding is always a conversation with the family to encourage guardianship for your 18-year-old, when in many instances, the preference for individuals like myself, I would encourage you, if your child is able to have conversations and able to rationalize on some level and isn't incompetent, I would encourage you to talk to your child about power of attorney, healthcare proxy, and living will, that they sign and appoint you, rather than get the courts involved in a guardianship. So parents will lose the right to make decisions for their children at age 18. That child, if they're able to understand on some level power of attorney, healthcare proxy, living will, they're considered an adult, they have capacity, and they can sign those documents. If they can't sign those documents are called advance directives, because they don't have the legal capacity to do that, then you would be looking for the courts to appoint you as guardian of your child. Next slide. The appointment of a guardian is because no one has the legal right to make financial and personal decisions for anyone over the age of 18. It's a court proceeding. So the proceeding for somebody who is transitioning from a child to adulthood and they're turning 18 is different than somebody who is in their 80s and lost capacity, but they were functioning on their own. The legal process is very different and much simpler for the parent who's trying to get guardianship over their 18-year-old. I say 18, but it's anyone over 18. But it's still a court proceeding. It still involves getting doctors involved to talk about the disability and you know, their feel of the individual's capacity. It's still a judge involved, reviewing all those documents and making sure that they feel that this is appropriate. Then the question becomes, if my child is looking for a guardian, do they have assets in their name where I have to be guardian of their property? Or am I just, they don't have assets in their name and I'm looking to be guardian of just them, like make medical decisions for them. So there is a lot of contemplation involved in this step and how we get there and what needs to be done. And we always encourage, if you really believe that your child doesn't have the mental capacity to understand on an elementary level some of what's going on here, you start processing and thinking about how you're going to start that guardianship proceeding by the time they're 17 and a half. Next slide. You guys have got so many questions that we went over a little bit, but I'm still willing to hang out with you and answer some more questions if you need me to, because the idea here is the next steps would be to create a plan. So if you have these questions and you have documents that you're concerned about whether or not everything is in place, that you took the time to listen to this presentation and you want to know if you have it all together, you create a plan. You speak to an attorney, you come in, we'll review your documents, we'll come up with a plan. If you don't have any documents at all, we'll come up with a plan and just discuss what your goal is, what you're hoping to accomplish, how you're hoping to protect your loved one, and how we can make that happen. You want to make sure that everything is comprehensive so that the plan that you put in place doesn't fall apart when you pass. It continues on the way you intended it, and we're going to help you implement that plan. Okay, so just as a summary, we discussed special needs trusts, first party, third party, pooled trusts. We went over government benefits like SSI and Medicaid and Medicare and Social Security disability, and the importance of being able to make decisions for your loved ones once they're over the age of 18. So I don't think there's any other questions in the Q&A, but I do know that there were some questions and I'm willing to hang out a few more minutes if anybody wants. I'm getting older, so I have to put my glasses on for this. My wife and I have a revocable living trust from 2000, which was revised in 2009. We have minor revisions to make the terms of the beneficiary allocations to our 3 sons, one of whom is special needs within the context of our trust. Are you able to advise us on the approximate cost? So the answer is yes, I can advise on the approximate cost, but I can't do it just in this presentation because I need to see the document to see how the document allows for the change, to know whether or not we can change it in a simple format. Do we need to restate everything and understand what the changes are? But I can certainly, if you show me the document, I can certainly have that discussion with you. Can meetings with a rep of Russo be done over Zoom or Skype? Absolutely. We were doing Zoom meetings even before the pandemic, and we certainly continued that, and we still do Zoom meetings. So absolutely, positively, Zoom meetings are an option, and I'd love to meet you on Zoom. Okay, the next question is, I have a special needs trust for my daughter. My grandson will administer it. What are his duties? So his duties are to make sure that the trust is for the benefit of your daughter, and his duties are to make sure that the monies are used for the benefit of your daughter. Is there a guide? There are some guidelines for how that happens, but most often we encourage the trustees to come in and have a conversation with us so that they understand their role and their responsibility and what needs to happen. How will the monies be invested? There's no restriction on the investment, although your grandson should really do sound investments, like cryptocurrency probably isn't the best investment right now because it's new and fresh, and there's a lot of question about it. So your daughter runs the risk of losing the assets in something like that. So it would probably be best to put it in sound, maybe a little bit more conservative investments depending on her age. And how have you seen bad will arising from trustees that the administering for relatives? So yes, we've seen it, but we've also seen very good relationships come out of family members managing money for other family members. So it depends on their relationship. It depends on how controlling the trustee tries to be, and if they're like using that to put some restrictions on things. But at the end of the day, it's all going to depend on how much they trust each other. If the recipient of a special needs trust passes away, is the remaining money in the trust subject to estate taxes? So I think that this person also asked that question in the context of the questions in advance, and the answer, I have to see the trust to see how it was set up to understand where and if estate taxes would be, where and if estate taxes are an issue here. I have to know who set it up, if the trust is the one paying the tax, if the grantor is the one paying the tax. There's a bunch of details that I need to best answer that question for you. So there is the possibility that there's a tax, but I need to know more information to give you an answer to that. Let's see. I have a special needs grandchild. How do I handle this in my will, maybe instead of per stirpes? So per stirpes means that those assets are going to go outright to that grandchild, unless there's provisions in the will to push it into a special needs trust. So what my suggestion would be that you don't leave anything up to chance. You update your will and make sure your will says that it goes to, if it goes to your children, and if not your children, then your grandchildren. But if this particular grandchild is inheriting, it stays in trust for them to be used for their benefit. So you specifically push it to the trust instead of letting chance take over. This one is not a question as much as a statement. That's a statement. I am interested to know the criteria for qualifying as special needs. Our daughter was special ed. So the qualifications for qualifying for special needs and these benefits, it will depend on the doctor's forms, the disability itself, and it will also depend on whether or not she's gainfully employed. I know that you commented that there's not enough money to live independently, but I would need to know those things to let you know about qualifications. Husband and wife, not together since '98, but not divorced. How to protect the assets of one spouse from Medicaid for nursing home care expenses of the other. So if you're not divorced, those assets you're exposed because you're still married. Best thing to do is to do a trust to protect assets after 5 years of establishing the irrevocable trust. And that's the best way to manage that. Let's see. I think I touched on that. I think I touched on leaving assets in a special needs trust. And the best way, some of the questions that you guys have asked prior to the seminar is just, you're leaving assets to your children who have disabilities. Will it affect them if you leave it outright? I always encourage you to leave it for them in a trust so that there's never any question, because even though somebody who is disabled can stretch over their lifetime retirement account funds, you have to then step back and say to yourself, if they're on government benefits, will that income affect the benefit they're getting? It's an income source, so it can be counted in that income column and lower the benefit they're entitled to. So you definitely want to make sure that you're taking all that into consideration. And it could be just a conversation. Come in, have a conversation with us, and understand your specific events and your specific assets and situations so that you're getting specific answers to your questions. My husband and I have a trust made for my daughter upon our deaths. What happens to the trust if she is then on SSI or Medicaid? So the answer to that is, depending on how the trust is written, it should stay in trust for her, so she maintains those benefits. But if the trust isn't written the right way, it could affect her benefits. So I would have to look at the trust itself to see that the language is in there so that we don't affect her benefits. All right. You guys were, even though you're a quiet crowd because I can't hear you, you were a great crowd. I love that there were so many questions and there was so much interest and you were engaging in the conversation. It makes me feel like I'm talking to somebody and not nobody. And thank you for all the hearts and the thumbs up. That really means a lot, because when we're not sitting in a room together and I can't see your faces, I don't know the immediate feedback of how you're understanding things. Don't hesitate to reach out to Ashley with more questions. I'd be happy to answer those questions via email, or you could come in and meet with me so that you are getting specific to your circumstance, because this is such an important area and there's so many things you have to take into consideration that general conversation like this gives you all the tools to understand there's options, but you need to know what your specific options are.
Okay. Wow.
Right.
Thanks, Deanna.
You're
Let
welcome.
me wrap it up here. So what makes Russo Law Group different? Our clients tell us that it's our dedication, accessibility, scope of legal services, and years of experience that gives them the peace of mind and confidence when working with us. We will not learn at your expense. This firm actually wrote the book on estate and elder law planning. Long Island News called us the leading elder law firm on Long Island. We've helped over 17,000 families and help a diverse group of people. We are proud to discuss our services in your preferred language, including Spanish, Italian, Mandarin, and conversational American Sign Language. Our founder, Vincent J. Russo, has been named one of the top 50 attorneys on Long Island. Also, our firm has 11 attorneys, and we stand ready, willing, and able to step right in and help. We have 3 convenient office locations. We will make home visits and, of course, those virtual appointments over Zoom. So if you have any questions, please let us know. Give us a call. On the next slide are a list of services that we provide and how we can help your family. We have a robust website at vjrussolaw.com. We offer terrific information, forms, checklists, resources, guides. So take advantage of it. It's all there for you.
There's also some good blogs on supplemental needs trusts and special needs planning. And so the blogs take one aspect of what we discussed today, and they can have a more in-depth discussion in that topic, on that topic. So don't hesitate going to the website to read through some of the blogs, because that's always very helpful.
Right. So
Sorry.
no, that's perfect. Thanks, Deanna. I forgot about the blogs. So please leave us your feedback in that post-webinar survey. It will appear on your screen momentarily. I know Deanna and I are looking forward to reading your responses. And in case you missed any portion of today's webinar, it was recorded and we will email it out to you. So Deanna, thank you for your presentation, for hanging out with us for a few minutes and going over those questions. That was great as always. So thank you. And
Thank you, and everybody have a great day.
remember to wear your green tomorrow.
Yeah.
All right. Have a nice rest of your day. Be safe.
Bye.